Hello, Constitutional Law class. In Unit 5, we discuss some aspects of federalism that potentially restrain the federal government in relation to the states, the 10th Amendment and the limits on the federal taxing and spending power. Previously, we discussed the federal government's power under the Commerce Clause. In this unit, we focus on federalism limits on the states. The Dormant Commerce Clause restricts the state's ability to enact economic regulations that interfere with interstate commerce when Congress has not otherwise acted. The Privileges and Immunities Clause limits the state's ability to enact regulations that unduly burden non-state residents. And the Supremacy Clause means that when Congress does act, federal law might preempt state law. We'll explore the constitutional doctrine under each of these principles in this unit. The Dormant Commerce Clause can be confusing because it isn't really a clause in the Constitution. Instead, Dormant Commerce Clause doctrine is inferred from the powers granted to Congress under the Commerce Clause. If Congress has the power to regulate in some area under the Commerce Clause but chooses not to regulate, does this leave an area for state regulation, or are the states precluded from stepping into the regulatory vacuum? The question was raised but not squarely decided in some early federalism cases, including Gibbons v. Ogden. Recall that Gibbons v. Ogden, decided in 1824, concerned whether a state steamboat monopoly could preclude a competitor from operating a steamboat route across state lines. Justice Marshall's specific holding in that case was that a federal licensing statute, authorized under the Commerce Clause, preempted the state monopoly. In reaching this conclusion, Justice Marshall also discussed in dicta whether New York had the power at all to issue state steamboat monopolies that affected interstate commerce, even absent a conflicting federal statute. Counsel for Ogden argued that the power of a state to issue something like a steamboat monopoly was like the power of taxation. The state clearly retains the power of taxation even though the Constitution also grants a taxing power to Congress. Ogden's counsel argued that the states likewise retained the power to regulate interstate commerce even though that power also had been granted to Congress by the Constitution. In dicta, Justice Marshall disagreed. According to Justice Marshall, the power of taxation must be retained by the states because a taxing power is indispensable to the existence of a political sovereign, and taxation at the state and federal levels need not be inconsistent. In contrast, Marshall said, if states were free to regulate interstate commerce, the states would be exercising the very power that is granted to Congress and doing the very thing which Congress is authorized to do. In other words, a state's regulation of interstate commerce would necessarily be inconsistent with the federal power to do so. So does this mean a state can never enact a law that has an effect on interstate commerce? The short answer to this question is the classic lawyer's answer. It depends. Specifically, it depends on whether the state regulation facially discriminates against out-of-state commerce or is facially neutral, and also on whether the state itself is a market participant. Let's summarize these rules, and then we'll dig into the case law to see how the rules have developed. The first question to ask is whether a state law facially discriminates against interstate commerce or not. If a state law does facially discriminate against interstate commerce, it will nearly always be held invalid under the Dormant Commerce Clause, unless the state can show there is no other means to advance a legitimate public purpose. The one class of cases in which the strict means-purpose test has been met concerns certain quarantine laws that restrict potentially tainted products from shipping across state lines. There's also an exception to the strict means-purpose test called the market participant exception. If the state is a market participant, a law favoring the state likely will be upheld, although defining the market in which the state is participating is crucial. The obvious question you'll want to ask here is what we mean by a state being a market participant. And we'll get to that later as we work through the case law. If the state law does not facially discriminate against interstate commerce, it may or may not be held invalid. Here, you need to ask two further questions. One, does the law have an impermissibly protectionist purpose or effect? And two, is the burden the law imposes on interstate commerce clearly excessive in relation to putative local benefits? This second question is sometimes called the residual balance test. Again, we'll flesh out both the impermissible purpose or effect test and the residual balance test as we work through the case law.